The economic substance doctrine is a common law, judicially created doctrine that applies only for income tax purposes. The basics of the rule is that if you engage in a transaction where there are no meaningful economic effects apart from a federal income tax benefit, then the courts will not respect the transaction for federal tax purposes. Gregory v. Helvering wasn't really an economic substance doctrine case. It was, in a lot of respects, more of a recharacterization case more than an economic substance doctrine case, as the doctrine has since evolved. But it is the background that from Gregory v. Helvering that many commentators and many courts have recognized as the starting point for the economic substance doctrine. ACM partnership. It was a case that was determined in the late 1990s. It was a Third Circuit opinion, and one of the judges in the case was is actually now a Supreme Court justice, Justice Alito. He was in the majority that ruled for the government. ACM involved a transaction using a partnership that trying to take advantage of what the government considered to be an unwarranted loophole in the contingent installment sales rules. We've had a push to have some sort of legislation to, some people say codify the doctrine, other people say the language they chose when they enacted these provisions was clarify, to establish at least a little bit more certainty. But no matter what, you're still going to have, to apply rules like this, a subjective determination as to whether a transaction should be respected. One of the major issues in economic substance legislation is what test are you going to apply? Until the recent legislation, there was a division among different courts as to what test to apply. The majority of courts adopted what was known as the conjunctive test. Other courts applied a disjunctive test. The dissenting judge in ACM referred to the economic substance test as a smell test. A lot of the case law spends a lot of time discussing the differences between a disjunctive test and a conjunctive test, and the legislation that was part of the health care bill clarified that was really the only clarification it did, was that the test that should be applied is a conjunctive test. You have to have a meaningful change in economic position and a substantial non-tax purpose. The general rule that a lot of times, and you see this in some of the cases with regards to some of these tax strategies, is if something seems too good to be true, it usually is. And if somebody tells you, oh, I have a way so you could have all of this interest and never have to pay tax on it, other than municipal bond interest, all this otherwise taxable interest and never have to pay tax on it, because this transaction will create interest deductions forever for you, then that's something you have to be concerned about. And at least until the 11th Circuit affirms Judge Vinson's ruling, the penalty is still out there.